Okay, good morning, everyone, and thank you for joining us on our Thomson Rogers Current Events webinar series. Today, we're going to be discussing how the pandemic has affected nursing homes in a class action we recently started. We have Stephen Birman, a partner with the firm Lucy Jackson and Ava Williams, both associates that have been working closely on the nursing home class action and what's been happening in those areas. We've got our plan is to do this every other week with various topics of interest that are in the news. Some of the things we've got that we're considering already is who's paying for CAT assessments, pitfalls of quoting, clients and their exact comments, OCF 3 best practice forms, and many more. And because we're into the summer, we think it's not all work related. We want to have some fun as well. So you'll be receiving today an invitation to a virtual wine tasting that Thomson Rogers is hosting with Bridgepoint Financial next Friday. We have the privilege of Tony Aspler, one of Canada's food and wine experts, to conduct a tasting with us. We're going to be doing a tasting of 3 different wines. And the intention is that you'll be able to go out and purchase these wines in advance at the LCBO and then go through with Tony a fun event on the nosing and flavors and what you can have with this. Just a fun virtual event to kind of start the weekend. And with that, we will be auctioning off some wine at the end, with the monies going to Polo for Heart and Grapes for Humanity. So look forward to seeing that either later today or Monday. I'll be getting the invitation for that. As usual, these virtual sessions are 30 minutes, thereabouts. We do record the sessions. We don't have any PowerPoint. It's just going to be our lawyers sharing their information with you. You're welcome to ask any questions using the Q&A function or the chat function so that we can answer your questions now, and the ones we can't get to during the session, we are happy to, we create the answers for you after we send the recording out. And with that, I'm going to pass it off to Stephen to get started. Stephen? You're on mute.
Thank you, Mark, and thanks everyone for joining us today. Lucy Jackson and I will primarily be talking about the recent class action that Thomson Rogers has started in respect of one of the nursing homes and the COVID-19 pandemic. And we're also open to taking any questions, which Ava Williams will handle as well. You may not know this. Many of you who are on the line have probably been working with us over the years in terms of our personal injury and car accident practice, but we have been involved for many years now in class action work as well. Historically, going back many years, we were the first firm to start the historic residential schools class action. In recent years, we've been involved in a number of different class actions involving educational institutions, pharmaceutical products. A recent case we had that was resolved involving a medical negligence situation as well. So the class actions are interesting. They give us an opportunity to diversify a little bit and to get involved in very important issues and represent large groups of people in that respect. The nursing home situation, as you'll know, is extremely tragic. What's going on in our nursing homes across the province right now, and over the last couple of months, it's been in the news. So what I'm going to tell you is not a surprise. But in terms of some background statistics, about 80% or so nationwide of the COVID-19 deaths have been in our nursing home, long-term care home facilities. There are approximately 600 or so long-term care facilities across Ontario. There's a diversification in terms of the ownership of these facilities. Some are for-profit, some are not for-profit, some are owned by government. In total, there's about 78,000 beds across the province. Our case that we currently have and others that we are looking into are focused on some of the circumstances in the worst homes and circumstances where we believe that deaths were avoidable. statistically speaking, what we're seeing and what's being reported in the media is that the for-profit homes are faring much worse than the not-for-profit homes. The CBC did an investigation the other day that was published on their website, and we're happy to share the article if you're interested. And what they found is that in the for-profit homes, so far about 5% of residents in for-profit homes across the province, and the for-profit homes occupy about half of the nursing home beds, about 5% of residents have succumbed to COVID-19 versus approximately 3% in not-for-profit homes and 1% or so in municipal homes. So the question that we have to grapple with, and we'll be grappling with in this litigation over the next number of years, and not just us, but government and commissions and others who will be looking at this issue and systemically what's gone wrong here, is why is this? Why have these for-profit homes fared so much worse? And what could they have done to address this situation? And there are a number of questions that we have and that we're looking into, and we're learning more every day, by the way, as we talk to families and gather information. Of course, one of the big challenges, and Lucy will talk a little bit about this, is that these residents right now are basically, in large part, cut off from the rest of the world. Their family members can't see them. Very few people are going into these facilities. Those that are in there, are dealing with triage and emergency situations right now. But we expect to hear from many of the inside workers over the coming weeks and months. A couple of the issues that have already come to the surface, specifically with respect to the for-profit homes, is there's a design question. Many of these for-profit homes have shared living spaces, 2 and 4 bedroom living spaces for the residents, large-scale shared dining spaces and recreational spaces. And across the province, there's a classification of beds within long-term care facilities. About a third of the beds, according to recent news reports, are at a standard that is not up to the current construction standards for nursing homes. So they may have at one point met the standard back when they were constructed decades ago, but they were never upgraded, and they never moved away from this shared living space model. And what the reports are indicating is that of these outdated facilities, a large percentage of them are in the for-profit space. So that raises an interesting question as to why it was that these spaces weren't upgraded. There's staffing questions that have been raised across the board. Now that's going to raise interesting issues in terms of what the reasonable standard was. But what we're learning and what we're seeing is that there were major staffing shortages in many of these for-profit homes before the current pandemic. And then, of course, there's going to be major questions about infection control policies and practices, whether these homes, many of them had proper protocols and pandemic control protocols in place as the legislation requires. So just a little bit about Altamont. This is the home that we've focused on and that our suit is dealing with. It's a home that's owned by a company called Sienna Living. It's a public company. It's listed on the Toronto Stock Exchange. The home has entirely 2 and 4 bedroom shared living spaces. There are 159 beds in the home, and tragically 53 of the residents have passed away. So that's a third of the total population within the home that succumbed to COVID-19. Over 75% of the residents contracted COVID-19, so it was a massive outbreak there. The first PSW in the province that died from COVID-19 was at Altamont as well. The military undertook, or the province undertook control of Altamont in late April, and the military was there as well. And it was one of the homes that was documented in the recent military report that I'm sure you've read about and that Lucy's going to talk about as well. And a lot of the issues that I've been talking about that seem to apply to for-profit homes are also prominent at Altamont, specifically at Altamont. In fact, it's a sea-level facility, meaning all of the rooms and beds appear to not meet the current standard. There are questions about PPE issues. which I'm sure you've heard about in the news. And that's an issue that's going to be explored through our litigation as well. And there's also major questions there about infection control. In fact, and Lucy may touch on this as well, but there are certain requirements with respect to government and ministry inspections at these facilities. And we went back and looked at the reports for Altamont over the last number of years and found that questions about their infection control protocols were repeatedly raised by the province. So there's a lot of information out there. There's a lot that we're learning and we're continuing to learn. And there's a lot that's developing and changing on an ongoing basis. And Lucy's going to talk a little bit about some of the protocols and bulletins that the government has put in place to address the situation.
Okay. Thanks, Stephen. So as you can imagine, since the outbreak of COVID-19 and the declaration of the pandemic on March 11th, the situation in the long-term care homes and the government response evolved rapidly. I think it was probably almost every week there was a new order or a new directive given by the government. So that would be the Ministry of Health or Ontario's Chief Medical Officer of Health, with recommendations and directives as to how these long-term care homes should respond and what protocols they should be implementing to help prevent the spread. As we know, residents at long-term care homes are exceptionally susceptible to COVID-19 and to complications arising, so such as developing pneumonia and death, unfortunately. So I'm going to run through a little bit of a chronology. I'm highlighting more of the more important directives that were made by the government, just to provide a sense of what was in place and what these long-term care homes should have been following in order to help prevent the spread of COVID-19 amongst the residents. I'm not going to touch on all of them. There were a lot, but I will touch on some of the more important ones. Okay, so the first, as of March 9th, so this is before the pandemic was even announced, the Ministry of Long-Term Care instructed long-term care homes to begin active screening of all visitors, residents, and admissions for COVID-19 symptoms. It was then on March 13th that the Chief Medical Officer recommended that all long-term care homes only allow essential visitors to enter. So as of March 14th, no family members, no non-essential visitors were allowed. It was only employees and then other healthcare workers that were deemed to be essential. So paramedics, for example. Otherwise, other privately hired treatment providers were not allowed in. So if an individual had a personal support worker or a private caregiver that they were technically not allowed into this long-term care home anymore. Subsequently, on March 22nd, short-term absences of residents were no longer permitted. So that meant that residents were no longer able to leave the long-term care home at all. This essentially created a total lockdown of the residents within these homes, and only the employees were able to enter. The first outbreak at Pinecrest and Bobcaygeon was on March 18th. This was the first long-term care home in Ontario that had a significant outbreak. Ultimately, and tragically, 29 of the residents died. I think this was the beginning of great attention onto the long-term care homes in Ontario and the requirement for the government to provide a very quick and serious response. As of March 30th, a directive was issued to immediately implement active screening of all staff, essential visitors, and anyone else entering the home for COVID-19. And the long-term care homes were also to conduct active screening of all residents at least twice a day for COVID-19 symptoms. And then residents with symptoms must be isolated and tested for COVID-19. It wasn't until around April 8th that all staff and essential visitors were required to wear surgical or procedure masks at all times and the duration of full shifts or visits while they were in the long-term care home. By April 10th, 2020, there was a directive that the long-term care homes could not unreasonably deny access to appropriate PPE to staff and visitors. Also, all healthcare workers or other employees who were within 2 meters of a suspected or presumed COVID-19 patient or resident would have to have access to appropriate PPE. It wasn't until April 15th that the government required that all symptomatic residents at long-term care homes and staff be tested. And then they were also testing asymptomatic residents or staff who had been in contact with a positive case. By April 22nd, employees at long-term care homes were no longer able to work at different homes. They could only work at one home. By April 21st, the ministry had recommended that every resident and staff member at each long-term care home be tested. So that was regardless if they were symptomatic or if they'd been in contact with a confirmed case. And then it was on April 24th that the government made a directive requiring long-term care homes to allow the government to provide additional resource and assistance, and that the long-term care homes would have to accept that. This was the same day that the Ontario government announced that the Canadian Armed Forces personnel would assist in providing aid to the long-term care homes. So as we know, and as Stephen mentioned earlier, that the military were deployed to 5 long-term care homes in Ontario that were deemed to be in desperate need of additional staff. So in order to get the military involved, the province actually had to ask for assistance from the federal government. And this was specifically to address these staffing shortages. So it was around on April 27th that the military personnel were deployed to 5 homes. Those 5 homes are Eatonville in Etobicoke, Hawthorne Place in North York, Orchard Villa in Pickering, Altamont, which is the subject of our class action, which is located in Scarborough, and then Holland Christian Grace Manor, which is in Brampton. Approximately 500 military service members were deployed to these 5 homes, and the operation, it was called Operation Laser. Ultimately, as we know, a report was drafted by the military personnel and dated May 15th, but it wasn't released until May 27th. In this report, pretty shocking observations were made at all of these homes, not only with respect to infection control. So a major issue was lack of access to PPE or inappropriate use of PPE. For example, double gowning or double masking, wearing the same PPE, so gloves, masks, and gowns while treating different residents, going from room to room. There were also a lot of issues noted with respect to general care that was provided to the residents at the long-term care home. And all of these observations are likely in breach of the Long-Term Care Homes Act, which sets a pretty rigorous standard and very specific requirements for residents at these long-term care homes with respect to nutrition, bathing, fall prevention, and of course, infection control. Interestingly, the military will play a very important role in the class actions with respect to these 5 homes. Because of the lockdown, we know that only essential visitors were able to enter, and it was the employees. It's going to be very difficult to get an inside look as to what was actually happening in these homes. And again, the residents of long-term care homes are incredibly vulnerable, but also many of them are suffering from dementia or other cognitive illnesses, which will impede their ability to provide evidence in a class action going forward or any lawsuit with regarding any alleged wrongdoing against them. So the military will play an important role, and as we know from an article that was recently published in the National Post, a spokesperson for the Canadian Armed Forces did actually confirm that the military will be able to be summoned to provide evidence or testimony, just as any other individual in the public would also be able to be summoned to be called as a witness. And their evidence will be very important in these class actions because the military personnel were some of the few people who were able to gain firsthand observation and access into these homes, which were on complete lockdown. I think now I'll hand it over to Stephen to talk about, I think you're going to talk about damages now, right? Stephen, you're on mute.
Darn, that mute button. Okay, I'm just going to do a quick overview about damages and how class actions work. I'm sure it could be a seminar or a session on its own, but you're probably thinking, what's next? And we see these class actions, they show up in the news, and then we don't hear from them again. How does this all work? So the first step in any class action, very different than the personal injury individual actions that we're used to dealing with, is the court has to authorize the class action to go ahead. It's called the certification motion, and it usually happens about a year or so after the issuance of the claim. And there the court looks at a number of issues, and there's going to be a lot of these certification motions potentially going ahead. There are a number of other class actions in respect of different facilities. And the court's going to have to decide in each case, is this amenable to proceeding as a class action? And the big thing they look at there is a question of, is there a common issue or something common about this institution or this group of institution that will allow the court to make a decision en masse that will advance this litigation? The second thing they look at is a class action here preferable to other litigation processes, whether you're talking about individual actions or arbitrations or other means of potentially resolving the issue. And we call that the preferable procedure criteria. And there they look at three questions, three criteria that have to do with access to justice, behavioral modification, and judicial economy. And for me, the big one here, Lucy touched on it, is going to be an access to justice question. You've got these vulnerable seniors, many of who have succumbed, others who may have long-term needs associated with these issues. And they're not the population that typically are able to find lawyers very easily who will take on their cases, sadly. They're difficult. They can be a little bit more challenging as clients potentially, but the age is an issue as well when you start to talk about damages. So I see a significant access to justice issue that would necessitate moving forward as a class. And then there's also the issue of behavioral modification. And this is such a big issue right now, not just today, tomorrow. It's going to be an issue for many months, if not years ahead, as the commissions and inquiries and investigations into what actually happened here continue. And the class actions provide one avenue. There will be others of potentially ensuring behavioral modification and reform to the long-term care system. So we're optimistic that the class action will be authorized to proceed. It's never a certainty. It's never a guarantee. It's a risk in any class action. There are other firms that have started class actions. They've taken different approaches. There's one firm that's basically named a corporate entity and listed all of their homes, 35 or 40 homes. We think that's a little more challenging than looking at it on a home-by-home basis, only because the circumstances in each home are going to prove to be very different in terms of when the outbreak started, what the response was, and what the outcomes were. So there's going to be lots of litigation. You're going to be hearing about this for years in terms of the certification, in terms of potentially arguments between law firms as to whose class action makes more sense. And of course, we're going to say that ours does. In terms of damages, the damages are similar to personal injury claims that we typically see. Of course, there's not likely to be loss of income claims. In fatality situations, we'll be dealing with Family Law Act claims. We'll have to deal with a hurdle, whereas courts don't give proper value to life when dealing with fatality situations. That's not just true for an elderly population. That's true in any of our cases. In motor vehicle cases, we see it as well. There's a massive constraint against those types of Family Law Act claims. The maximum award in those situations is typically in the $100,000 to $125,000 range, and that's often for a very young person. So the damages on that respect are going to be controversial, I suppose. But we're going to argue that that in at this stage of someone's life, in your golden years, there's no reason that the damages for family members should be undervalued or diminished based on age. And any attempt to do that is really a form of discrimination. There'll be claims potentially in respect of medical costs. There's a huge question as to what the long-term implications of COVID are going to be. Is there going to be an ongoing need for medical monitoring? Are there going to be ongoing medical costs for some of these patients and residents? We don't really know, but that's something that's going to be an issue as things evolve. And there's of course going to be some OHIP claims as well in respect of the hospitalizations. Just my takeaway before I turn it over to Lucy, I think this is a significant issue, what's happened in our long-term care homes. I think it will prove to be of historical importance. I think it's important that you understand that our focus is not on every home, and it's certainly not in any way on the staff within the home who have been the frontline soldiers in all of this. It's on the for-profit corporate entities who let their homes fall into a situation of neglect, such that they weren't in any way prepared for what happened and for the outbreak. I think it's important that you understand that lawsuits are about compensation, but they're also about behavioral modification, and this will prove to be one avenue, along with the provincial commissions, the independent investigations, and other things that will be done in the push towards reform. Now, one question you may have is, how does the province fit into this? Lucy's talked a little bit about some of the bulletins and the guidelines that they pushed along. Just because they implemented them doesn't mean they were all done properly or accurately or at the right time. And Lucy's going to talk a little bit about potential claims against the province before we wrap up for today.
Thanks, Stephen. Yeah, so the province, so the government under the Ministry of Health and Long-Term Care actually holds a oversight role over how these long-term care homes operate. Even though they're operated by for-profit companies, they operate, a license has to be granted by the ministry in order for them to operate. I mentioned before, we've got the Act, the Long-Term Care Homes Act, which provides very detailed requirements that these long-term care homes have to comply with when operating these homes. In order to ensure that the long-term care homes are abiding by these laws, the government has the ability to conduct inspections or investigations in these homes. Under the law, the government is supposed to be doing an inspection annually at each home. However, we've found that hasn't been the case. I think for 2019, it was a shockingly low number of annual inspections considering the number of long-term care homes that are in the province. However, these inspectors will go into the homes based off of either a complaint made by a resident, a family member, or it could even be an employee can make a complaint, and then the ministry is responsible for investigating that. There's any investigation report will be made public with the findings. There's also the ombudsman, which is the Office of Last Resort. So if there's a complaint and it's found that the long-term care home hasn't adequately responded, then it's possible to make a complaint to the ombudsman, which is an independent and impartial body, which is meant to represent the interests of the public. They will then investigate the complaint. However, unfortunately, the ombudsman traditionally don't have a lot of power. Normally, they can just issue recommendations for how to best respond. Interestingly enough, the ombudsman is launching its own investigation to examine whether the government, so the ministry, has been adequately overseeing these long-term care homes, specifically in the COVID pandemic. The provincial government has also stated that an independent commission will be launched. I think it's going to be in September, to investigate the issues that were raised, most notably after the military and the military report. So given the government has this very strong role in overseeing that the long-term care homes are adequately implementing their what they're supposed to be doing and protecting and providing care and treatment to these to the residents, there are lots of questions whether or not the government has failed in that, and whether or not that has led to the long-term care homes not being able to properly respond, and or the residents being infected by COVID and the serious spread that we've seen. Historically, though, claims against the government with respect to infectious diseases have been unsuccessful. Two examples are after the West Nile outbreak in 2002. Our Court of Appeal found that the government does not owe a duty of care to individuals to protect them from the spread of an infectious disease. Rather, the government owes a duty to the public at large. This is the same after the SARS outbreak as well. There was a proposed class action where the plaintiff, so the individual, had contracted SARS when admitted to a hospital. There were allegations that the province had prematurely eased its infection control procedures, and it had therefore resulted in this second outbreak of SARS in May of 2003. Again, though, our courts found that the province does not owe this duty of law, or duty of care, sorry, to individuals. It's to the public as a whole. However, there was a note that if the healthcare facilities, so the hospitals, are not adequately implementing the directives given by the government, then it's possible that the healthcare facilities would owe a duty of care to these individuals. And if they were found in breach of the directives, then it's possible to bring a claim against that healthcare facility. So based off of that history, claims against the government are notoriously difficult. However, as we've seen, the government has issued a number of orders and directives with respect to how long-term care homes, for example, should be properly responding to prevent the outbreaks. And that's the basis, a huge basis of our class action claim, that if these long-term care homes aren't adequately responding or implementing these directives, they do owe a duty of care to the residents. And if they've breached that duty, then we can try and establish negligence.
So we have a question for you two, and it's, will there be a consideration for the workers who do go in terms of their personal obligation to remain, provide a standard of care, and also how much the home supports them to meet their responsibility via training, supplies, and emotional support? So to me, I'm reading that question as, will the workers who have to go in and maybe the home has failed them, will they be considered in the class action? That's how I read the question.
Yeah, so that's a good question. Unfortunately, workers are not part of our class group. Employees are not part of our group. They can't be, because of the workers' WSIB system that's in place in Ontario, which is kind of sad in a way. We have been contacted by some family members of some of the workers who have asked that question. At the same time, the WSIB system will offer them some protections as well, and some quicker relief than any sort of class action lawsuit would. So no, they're not part of our class, if that was the question.
Yes, it was.
Okay.
Hey, there's also one in the chat there, Ava. I don't know if you can answer.
Let me, okay. So it is my understanding that class action lawsuits had been initiated by families against senior care facilities prior to the COVID-19 outbreak, identifying lack of care issues. The pandemic just brought these issues to the forefront of the public and the government. Will your class action lawsuit be a part of that process in any way, and how?
Okay, so I can answer that one as well. There were a few class actions started a couple of years ago against Sienna and Riviera and others. None of them were certified, as it's my understanding, and they ended up, for whatever reason, proceeding as individual actions for the reason that I talked about earlier, that there just wasn't a common theme to them, or at least it wasn't specific enough that, you know, the court felt that there was, or the lawyers who were handling those claims felt that there was a viable chance to get certified or authorized to proceed. Here, we believe there is a common theme. The tie-in is, of course, the COVID-19 pandemic and some of the other issues that we talked about earlier. Our class action is, as it's currently defined, is limited to the beginning of the pandemic period, as it started in Ontario with the first case in or around January of this year. So our claims and our class definition wouldn't go back before that, and those actions would continue separately if they're still in the courts. But that's a good question.
Okay, maybe you can answer the other one, but we're running out of time there. I don't know if Ava or one of the others can see the chat there.
Where does responsibility lie for the lack of PPE with government and care facilities? As a home care provider, we were very restricted on access to PPE in the early stages of the pandemic because they wanted to ensure that the PPE was available to the hospitals.
Lucy, you want to take that one?
Yeah, I can take that one. So in terms of providing PPE to the employees, that the government did provide in one of its directives in April that it was a requirement to provide PPE to the healthcare workers and employees at these homes. Obviously, that's going to be a difficult issue to look at, especially if the long-term care homes can then point to saying, well, we would have provided this if we had enough PPE. So that's definitely going to be a challenging issue if there's an access issue for the companies themselves. But ultimately, it's their responsibility and their to provide the PPE to their employees, and that was part of the government directive to ensure that that's available in order to provide safety measures for the employees.
All right, well, we have gone a little bit over on time. Thank you guys for your presentation today. For anyone, if you have other questions, you can obviously get in touch with Stephen, Lucy, or Ava directly. And I said this is recorded. We'll be sharing the recording with anyone who registered for the event probably in 2 weeks. So they have that with the announcement of the next session we'll be doing. With that, thank you, everybody. Stephen, you want to close out?
Thank you.
Okay.
Thank you.
Thank you.
Thank you.
Stay safe.